Well, welcome everyone. Thank you so much for joining the Center for Biological Diversity today for a special webinar. We're bringing you into the story of the urgent fight to protect Florida's world-famous Everglades. I see people are still joining the call, so we'll get started in about a minute. And thanks so much for being here. I'd like to say, just a welcome. And I want to introduce you to two of the center's incredible rock star lawyers, Elise Bennett and Jason Tatoy, who are defending the Everglades from a polluting detention center. Elise is the director and leader of the center's Florida and Caribbean region, and Jason is a senior attorney here. I'd also like to give a shout out to the center's Chief Development Officer, Paula Simmons, who's joined the call, as well as Laura Enriquez, who is helping us make sure the webinar runs smoothly today. Before I hand it over to Elise, on behalf of all of us here at the center, I want to share our deepest appreciation for the generous financial support and actions already taken by so many of you on the call to support the fight to save the Everglades from this urgent threat. Elise and Jason will be giving you an inside look at the center's rapid legal response and how they're fighting for Florida's precious wetlands and panthers and other species who live there. There will be a Q&A after their presentation, so feel free to type your questions below or email them to questions@biologicaldiversity.org. The call is being recorded today, and we'll email you a recording in a few days. Just thank you again for being on the call, and I'll turn it now over to you, Elise.
Thank you, Gretchen. I'm going to go up ahead and pull up some pretty pictures here. So I always find that helpful to find myself when I'm talking about an issue. Here we go. Is everybody seeing the slides okay? All right. Welcome, everybody. Thank you so much for being here today. My name is Elise Bennett. I'm the Florida and Caribbean Director and a senior attorney at the center. And I work alongside Jason Tatoy and many other lawyers, scientists, and advocates with the center and with our partners to defend Florida and the Caribbean from some of the greatest threats to endangered and threatened species. I know most of you are probably familiar with the center, but just as a quick refresher, the center was founded in 1989, and it was to secure a future for all species, great and small, hovering on the brink of extinction. And we do this because every living being inherently deserves to exist, and because we know that the loss of any species is a deep loss for humanity. Our health and our well-being is tied up with the well-being of our biodiverse ecosystems. So when faced with the task of defending an important preserve, home to burgeoning native biodiversity, from endangered Florida panthers to tiny Florida prairie clovers, it was a no-brainer that we would team up with Friends of the Everglades to fight the detention center development. But before we jump in, for those of you who maybe have not had the pleasure of getting your feet wet in Big Cypress National Preserve, I'd like to take you on a quick tour. This is Big Cypress National Preserve. It's a critical valve in the liquid heart of Florida, known as our Everglades. And it's part of the National Park System, and it safeguards a diverse array of ecosystems, including freshwater sloughs that are dotted with tree islands, cypress swamps, marl prairies, mangrove forests, and globally critically endangered pine rocklands. These systems are habitat for hundreds of endangered and threatened plants and animals, including federally protected ones like the Florida panther, the Florida bonneted bat, the eastern indigo snake, the Everglades bully, that's that little plant there on the bottom. And while white ibises are not federally listed, I just really love that picture. It's actually from a little swamp slosh I took back in Big Cypress a few years ago. This place is also beloved by so many people, and here are two of them. It's my father and myself. Many people who live here in Florida identify with the Everglades, and we take great pride in its restoration and in its protection. And others who visit recognize that these critically important ecological services that it offers to us, including buffering the state from hurricane-force winds and from flooding to water filtration. But most importantly, this place is the homeland of the Miccosukee tribe and the Seminole tribe, who've been primary stewards of this area for time immemorial. This here is an image from Orlando Weekly of Miss Betty Osceola, who's an environmental activist, educator, and elder from the Miccosukee tribe, and who has been on the front lines of defending Big Cypress and the Everglades. So now I'm going to take you time traveling back to the 1960s in the middle of the Everglades to a plot of land slated to become the world's largest jet port. As you can imagine, building an airport in the middle of the Everglades sparked controversy, and after significant environmental outcry spearheaded by friends of the Everglades founder, Marjorie Stoneman Douglas, and leaders of the Miccosukee and Seminole tribes, the U.S. Department of Interior commissioned a 1969 report to assess the ecological impacts of a development proposal here in the Everglades. This report was a precursor to modern federal environmental reviews that we have today, and it persuaded then Florida Governor Claude Kirk and later President Richard Nixon to reverse course and oppose the project. The jetport plan was ultimately abandoned, and only one solitary runway remains on the site to this day. Instead, what this close call did was it spurred the creation of Big Cypress National Preserve, America's very first national preserve. And it also kicked off the environmental decade when US Congress passed foundational environmental laws like the National Environmental Policy Act, the Clean Water Act, and the Endangered Species Act, which President Nixon signed into law to safeguard our clean water, clean air, public lands, and biodiversity for generations to come. And to this day, that one solitary runway in the middle of Big Cypress has served as a reminder of the cost we could have paid for thoughtless development in one of America's most treasured natural places. Though over time, it has largely faded into the background, and pilots occasionally use it for touch and go training, it's not a busy or highly developed area, and most folks who visit Big Cypress don't even realize it's there. But this year, everything changed very quickly, yet again throwing the site into the center of conservation controversy. On June 19th, many of you might remember, Florida Attorney General James Uffmeyer announced this vision for a mass immigration detention center in the middle of the Everglades that he cruelly called Alligator Alcatraz, based on a fiction that alligators in the surrounding wetlands would patrol the site. Of course, those of us who know the Everglades well know that this notion's ridiculous, and the facility itself is the threat. The next day, the US Department of Homeland Security approved the idea and agreed to reimburse Florida for the money spent on it. So began a federal and state partnership to build this development in the middle of the Everglades. And it was a radical transformation at the site. What was once this little used paved airstrip effectively became a bustling town overnight. With no plumbing, waste management systems, or other utilities to support this facility, trucks brought in heavy loads of equipment, massive generators, stadium-style lighting, and dump trucks full of asphalt and fill. And Floridians in the area who came to see what was happening could only watch in horror as this place was developed. We also saw heavy-duty tent structures erected, dozens upon dozens of housing trailers, portable bathrooms, dumpster, and more, all dragged onto the site to support the detention of thousands of people, as well as thousands more to support the facility that was being built. The facility also brought massive amounts of pollutants, everything from human waste to jet fuel to mosquito treatments, things that weren't occurring at the site, certainly beforehand, because no one was there on site. And despite claims that this was a temporary project, the public watched as new paving smothered new areas across the site. Dr. Christopher McVoy, who's a soil scientist, a wetland expert, and a Friends of the Everglades board member, actually analyzed these areas of new pavement, as seen in these exhibit excerpts above, and estimated that more than 20 acres of new pavement had been laid. And we know today that it's even more now. All of this is closely hemmed in by vulnerable wetlands. And this means that runoff from the intense use of the existing and new paved areas is moving directly into those surrounding wetlands. And it's also important to note that because of the nature of the soft-sided structures, this facility is also incredibly vulnerable to hurricanes. One bad storm on track for this area is a safety, logistical, and environmental nightmare. But what else is at stake? Well, there's a diversity of endangered and threatened species living in this area. Big Cypress National Preserve is one of few remaining places in Southwest Florida that is, or at least should be, protected from massive, thoughtless development. That's part of what makes it so important to protecting endangered species. For example, this area has long been a part of the territory of the endangered Florida panther. That's the map all the way on the left. All of those dots are pings from a radio collar worn by a panther. There were multiple panthers that have been fitted with these collars, and we're able to track the areas they use. And as you can see, so I can get my pointer here. This is the runway. This is the larger area of the site. And all of those red dots are panther collar sightings. These little yellow dots are dens. This area is also within the core foraging area of the threatened wood stork. There's the wood storks right there. All of these areas with this kind of patterned blue covering over it, those are foraging areas, wetlands that wood storks use to feed themselves and their families. And the site also overlaps with and is adjacent to critical habitat for Florida bonneted bats, Everglades snail kites, and proposed critical habitat for several Florida plants that are threatened and endangered, including Everglades bully, Florida pineland crabgrass, and Florida prairie clover. Here's a list of even more species that could be impacted by the site. This comes from the U.S. Fish and Wildlife Services database, and none of these species were considered when this project moved forward. I did want to take one more moment and just draw your attention to one particularly special species, and that is the Florida panther. This site is within an area that's critically important for Florida panthers, who once roamed much of the Southeast, but who are now reduced to a very small population, fewer than about 120 to 230 individuals that are nearly hemmed into the Southwest Florida by development and roads. Habitat destruction is one of the driving threats for panthers, along with car crashes. We lose about 20 to 30 panthers each year alone to car crashes. Another threat is something called intraspecific aggression, a phenomenon that occurs when two panthers are forced to fight to the death over territory. And this can be made worse by reducing the areas that they have left to live in. These maps were created by a decades practiced panther expert, Randy Kautz, and they show that this facility is right within core adult panther habitat. That's over here. The site is right here. And also within an area that's known as the panther primary zone. There's the site right here, and that gold area is the primary zone. The primary zone is considered essential for the survival and recovery of the Florida panther, and experts have agreed that there can be no net loss of area in there. Panthers need every square mile, every acre that's left. And if something is destroyed, it needs to be made up somewhere else within the primary zone. Unfortunately, human activity and artificial lighting at this facility has effectively evicted Florida panthers from about 2,000 acres of this really important area, which increases the risk of road deaths, intraspecific aggression, and more. And speaking of the artificial lighting, it can be seen from more than 15 miles away, disrupting night skies that are normally so dark that Big Cypress National Preserve has won an International Dark Sky Park designation. The light pollution can also be seen from satellites. If you look over on the right, there's a satellite image on top, which shows the site on May 27th, darkness. And then one below, which shows the site on June 27th, soon after the construction began, and you can see significant light pollution. Not only does this light blot out the night sky to the chagrin of stargazers who come to Big Cypress explicitly for that purpose, but it also destroys the dark open skies that endangered Florida bonneted bats need to feed themselves. And finally, and importantly, the Miccosukee tribe of Indians of Florida, who intervened as co-plaintiffs in our case, were also harmed by closing off access to trails in the area of the site and risking harm to waters, wildlife, and nearby important cultural sites. Those are mapped here. This is an exhibit from the case. And here's the villages. And for reference, the site is right here on this map, and the site is over here on this map. Many of these areas are downstream from the site too, which raises a huge concern for water quality contamination. And then looking at the bigger picture, it's important to recognize that the setting of this small area, which is just about here, is the roadmap for Everglades restoration. If you look at these maps of Florida here, you get to see what the natural flow once looked like, where water flowed from the Kissimmee River through Lake Okeechobee down to Florida Bay. That's a healthy Everglades. Over time, it was ditched and dammed, and water was moved into unnatural areas. And we're now trying to restore that flow from Lake Okeechobee down to the Florida Bay. And as you can see, the site at issue is right here in the way of Everglades restoration. This project thwarts this important work, and it undercuts billions of dollars that had been invested in a healthy and restored Everglades. So with so much at stake, attorneys at the Center for Biological Diversity teamed up with Friends of the Everglades and even more attorneys at Coffey Burlington and Earth Justice to file a lawsuit challenging this incredibly damaging facility. Within days of construction commencing, we filed our complaint, along with a motion requesting a temporary restraining order and a preliminary injunction. And that was to stop the environmentally destructive activities before they caused irreparable harm to the wildlife, wetlands, and nearby communities. The main federal environmental claim in the complaint arises under the National Environmental Policy Act and the Administrative Procedure Act. These laws govern federal agencies and the actions that they take. So we're going to talk a little bit about NEPA, or the National Environmental Policy Act. It's often called the Magna Carta of federal environmental laws, and ensures that federal agencies consider the significant environmental consequences of their proposed actions and inform the public about their decision-making. This is supposed to occur before the agency takes action, as courts in our jurisdiction have often explained. The goal here is to ensure that important environmental consequences will not be overlooked or underestimated, only to be discovered after resources have been committed or the die otherwise cast. So the short of it is, the goal of this law is to look before you leap, a common sense adage. And in this case, the construction of this federal immigration detention facility, it's inherently federal, and it occurred without any kind of analysis whatsoever. It's kind of ludicrous to think that a federal detention facility could be constructed overnight in our most famous and sensitive ecosystem without any review at all. It really couldn't be a clearer cut case. Unfortunately, even though we filed our motion to temporarily halt the activities at the site long before the facility was even operational and before detained people were even brought to the site, it took more than a month to finally have our day in court. And it actually turned out to be multiple days over the course of 2 weeks in court. We and the Miccosukee tribe put on numerous witnesses who spoke to the value of and their interests in Big Cypress and the Everglades, the destructive activities they witnessed occurring at the site, and the impacts to the surrounding environment. For example, Center member Amber Crooks spoke to her deep love and knowledge of Big Cypress and how activities would harm her interest in hiking, biking, and observing endangered and threatened species like the Florida panther and the Florida bonneted bat. Friends of the Everglades member Jessica Namath, who stood sentry at the facility entrance for days on end, testified to witnessing countless generators, industrial lights, and other equipment being brought onto the site. Soil scientist and hydrologist Dr. Christopher McVoy testified to his observations of the site and the impacts of new paving constructed near vulnerable wetlands. And panther experts Dr. Robert Frakes and Randy Kautz prepared significant reports, and Kautz, with his decades of experience working for the state and federal wildlife agencies, testified to the multifaceted threats to Florida panthers, from habitat destruction and increased risk of dying on roads. The plaintiff's presentation of evidence was so compelling that Judge Williams granted our request to issue a temporary restraining order mid-hearing to ensure that no new paving or construction would occur before she could decide whether to issue an injunction. So this was our first win in this case. After that, the federal and state governments called their witnesses. Well, They actually weren't interested in calling their witnesses, but ultimately decided to call just one, the director of the Florida Department of Highway Safety and Motor Vehicles, who unfortunately was unable to testify to key details regarding the operation of this site. Ultimately, what's interesting about this case is that the government defendants don't deny that they failed to do the environmental review required by NEPA. They instead argued that NEPA wasn't required because, as they claim, this is entirely a state action. In their words, the state of Florida has essentially gone rogue and is enforcing federal immigration law all on its own. And we know that this can't possibly be the case. And it's directly contradicted by countless public statements by Department of Homeland Security Secretary Noem, Governor DeSantis, and even President Trump, that this facility is the product of a federal and state partnership. And so the district judge, Kathleen Williams, agreed with us. We won our preliminary injunction, and Judge Williams issued a comprehensive 82-page order that explained that we were there in the right court. We had demonstrated we were likely to prevail on our NEPA claim, that we had established ongoing and irreparable harm to the plaintiff's environmental and the tribal interests, including to wetlands, water quality, and endangered species, and that it was equitable and in the public interest to pause those harmful activities for the benefit of Floridians and Americans until the case could be decided. So I pulled a couple greatest hits here from the 82 pages. I didn't think you want to read all 82 here with me, but she made some really critical findings. She found that there was a federal agency action. She said, if it walks like a duck, quacks like a duck, and looks like a duck, then it's a duck. In other words, if we're building a federal detention facility, it's a federal action and it requires federal environmental review. She also found that there was a failure to comply with the National Environmental Policy Act. She said there was no process at all. The defendants consulted with no stakeholders or experts and did no evaluation of the environmental risks and alternatives. She found significant environmental harm. She said there were ongoing harms to organizational and tribal members' enjoyment of the preserved areas because of industrial lighting, noise, traffic, and securing the perimeter. And finally, she found that it was in the public interest to stop these activities. She noted that neither the state nor the director of the Florida Department of Highway Safety and Motor Vehicles could explain why we need a detention center in the middle of the Everglades. And the state didn't consider other alternative locations. And she concluded with hearkening back to the history I shared earlier. She said that every Florida governor, every Florida senator, and countless local and national political figures, including presidents, have publicly pledged their unequivocal support for the restoration, conservation, and protection of the Everglades. This order does nothing more than uphold the basic requirements of legislation designed to fulfill those promises. In other words, this is a no-brainer. It's common sense that a review needed to happen here. So Judge Williams moved forward with a well-ordered wind down. She prohibited additional industrial style lighting, prohibited additional paving, filling, excavating, new fencing, and prohibited any other site expansion, including erecting additional buildings, tents, dormitories, and other facilities. And she ordered that within 60 days, which would have been by October 20th, and once the population attrition allowed, to remove temporary fencing so that the tribe members could have access again, to remove the harmful industrial lighting, and to remove those pollutants, generators, gas, sewage, and other waste and waste receptacles. It was a measured order, though. It did not prohibit maintenance and repairs needed for safety and environmental protection. And she noted that this injunction should apply to all actors at the site because this was inherently a federal action. What's kind of interesting too is that even before Judge Williams issued this order, the number of people detained at the facility had already dwindled from over 1,000 to fewer than 400, and an internal email indicated it would be empty within days. Nevertheless, Florida and the federal government immediately appealed the same day, and they raised two questions: whether the Southern District of Florida, where Judge Williams sits, was the proper venue, which was an argument that they failed to raise at the beginning of the case and only raised once Judge Williams was assigned to the case. And then the other question they raised was whether that preliminary injunction was entered in error. They also asked the 11th Circuit Court of Appeals to stay or pause Judge Williams' order until the appeals court could consider the merits of their appeal. Unfortunately, after the parties briefed the motion, a two-judge appellate panel majority stayed or paused the lower court's injunction, which means that activities have been allowed to continue at the site so long as this order stays in place. The order also stayed all proceedings in the trial court, which is highly unusual for a case like this. The panel majority, Judges Barbara Lagoa and Elizabeth L. Branch, found that the plaintiff groups were not likely to succeed on their National Environmental Policy Act claims, taking a narrow view of when this law should apply and discrediting the trial court's factual findings. But the decision earned a rather stern rebuke from Judge Adalberto Jordan, who dissented from the decision to grant a stay. He noted the highly deferential standard that the appellate court should have used when reviewing Judge Williams' order, and noted that defendants' multitude of public statements confirmed that this indeed was a federal project that should have been subject to National Environmental Policy Act review. He also noted that the majority had not given proper weight to the lower court's factual findings regarding irreparable environmental harm, and indeed had ignored those findings of environmental harm altogether, only giving weight to the government's alleged interests in enforcing federal immigration policy. So, given that environmental harm is now occurring at the site again, we moved for an expedited briefing schedule, which lands us with an oral argument in mid-January, and we'll be working on briefs through the fall and winter seasons. We also asked the court to reconsider its decision to put a pause on the proceedings in the trial court. We have other claims unrelated to the National Environmental Policy Act, including violations of the Endangered Species Act and the National Historic Preservation Act. And those can and should move forward. And we're awaiting a decision from the panel on that request, which could come any day now. So what's next? Well, I'll say this. All hope isn't lost. This is just a pause in the injunction, and the injunction still exists. And we're gearing up to defend that injunction before a fresh panel of 3 appellate judges. There's a lot more work to do once this interlocutory appeal is decided, including developing evidence on our existing claims and pursuing even more violations of environmental law. And so this is where I'm going to turn it over to my good colleague and member of the legal team on this case, Jason Totoy, to speak a little bit more about those other claims that we plan to proceed on.
Well, thank you, Elise. Good afternoon, everyone. As Elise mentioned, we have a series of pending claims that we're going to be filing pretty shortly here. In July, we provided the statutory required 60-day notice of intent to bring a claim regarding a violation of the Endangered Species Act. We also included a notice to the defendants that we intend to also bring a claim related to the National Park Service Organic Act. And so I'll begin with the Endangered Species Act. The ESA is our fundamental statute here in the United States regarding the protection for listed species. And the heart of that statute is a requirement that all federal agencies consult with the U.S. Fish and Wildlife Service to ensure that their actions do not jeopardize listed species. And it also prohibits the take of an endangered species by any person. And take is construed and defined very broadly. So it's not just the direct killing of a species, individual species, but it also includes actions that harm or harass a species as well. And so plaintiffs are suing both the Department of Homeland Security and ICE for failing to consult with the service regarding the construction and operation impacts of the detention center. We're also going to be bringing suit against both the federal and state agencies for causing the take of federally listed species. including the Florida panther and the Florida bonneted bat. So I'd like to focus here briefly on the Florida panther that Elise discussed earlier is a real keystone species here in the state of Florida, and it's one that is perhaps will be most directly impacted this project. One way in which this detention center is causing considerable harm to this species, as we've already provided an extensive testimony already at the district court level, was that the operations on this site are casting enormous amounts of light pollution in the area. And our expert, Randy Kautz, determined that at least 2,000 acres of habitat has been rendered unsuitable for the panther because of this light pollution casting so far and wide across its habitat. 2,000 acres for a species that's imperiled and is already, as Elise mentioned, hemmed in, so to speak, in Southwest Florida, is a significant impact that should have been considered and the subject of a very thorough consultation, but it never was. Turning to the National Park Service Organic Act briefly, I wanted to begin with this quote by the author Wallace Stegner, who often spoke and wrote a lot about. He was about the West in his novels and other writings, but it's appropriate and applicable nationwide. He said, "National parks are the best idea we ever had. Absolutely American, absolutely democratic. They reflect us at our best rather than our worst." And it was there that over 100 years ago, the National Park Service was established. And that's the agency that serves as the custodian or steward of our national parks. And this act is notable because it directs the Park Service to regulate the use of parks in such manner and by such means as will leave them unimpaired from the enjoyment of future generations. And it's been very well established that the National Park Service's authority to protect national parks and preserves, including Big Cypress, it extends to activities not just occurring within those boundaries on federal land, but also on non-federally owned land encompassed within those boundaries when they present a harm to national park resources. I could just say that just about every Circuit Court of Appeals has recognized this throughout the nation. This has been a longstanding principle, including the 11th Circuit. And oftentimes, this arises, for instance, when certain private individuals are perhaps recreating in such a way that is causing harm to a national park or preserve, and the Park Service has to step in and protect the park. And I would submit that in many instances, those types of harms kind of pale in comparison to what we're dealing with here. That is the direct result of federal and state actors. So Big Cypress National Preserve was established to assure the preservation of all these wonderful values that are in the Big Cypress watershed, from the natural, the scenic, and the hydrological. And we contend that the construction and operation of this mass immigration detention facility is using and impairing the Big Cypress National Preserve in contravention for the values in which it was first established. And what is perhaps surprising, I think in all my years at least of work, is that I have never seen such radio silence as there has been in this instance from the Secretary of the Interior and the Director of the National Park Service when it comes to what is being done to protect Big Cypress National Preserve. This type of inaction doesn't comport with the mandate of the Organic Act, which provides for this that directs the Park Service to take affirmative action to protect these values. And it's therefore that's the reason why we're bringing suit against the Secretary and the Park Service to compel them to take action. And I think with that, I'll turn it back over to Elise.
Thank you, Jason. So I think what's perhaps clear in this presentation is that the threat to the Everglades and to our landmark environmental laws that are meant to protect our interests in public lands and clean waters and biodiversity, that threat remains. The government defendants continue to invite the courts to interpret laws like the National Environmental Policy Act in a way that not even the Everglades is safe from unfettered development. And if the world-renowned Everglades aren't safe, what is? And so this fight for us is far from over and has only become more important. We're energized for the next round. But most of all, we're really, truly grateful to all of you for your contributions to the cause. To date, center members and supporters have submitted more than 20,000 letters in opposition to this cruel and destructive project. And we're seeing Florida officials beginning to cool on the idea, questioning at the very least, whether this wasteful, destructive project really makes sense. Your generous donations have also fueled this fast-paced court fight for the last several months. We've been working day and night, working with experts, preparing reports, showing up at court, working late into the evening. And we know there's still more work to do. We're going to need to keep on the pressure in the federal courts and in the court of public opinion. And so we'll be working with the legal team, we'll be hiring our experts, and we'll be doing more as we gear up for this next phase. And I just wanted to share that I think, with any loss, there can be a feeling of sadness or hopefulness. I think often for us, we describe it as a gut punch. But we have great hope for the Everglades because we know that we're on the right side of the law, we're on the right side of history, and we're working shoulder to shoulder with all of you and all of our partners across the state and across the nation. And so, I just want to leave you with a feeling of hope. We're not ready to give this up. We're ready to fight, and we know what's at stake. And we're so grateful to be moving forward with you. And I'll go ahead now and I'll turn it back over to Gretchen. Thank you so much for your time and for the opportunity to share a little more of the behind the scenes of what we've been doing in this case and what we have planned for the future.
Well, thank you, Elise and Jason, for bringing us into the Everglades and Big Cypress Natural Reserve. This project's sudden construction in the heart of the Everglades is such a shocking violation of environmental laws and is clearly incredibly dangerous to an essential sanctuary for Florida's wildlife. Before we go into the Q&A, I just want to, restate or reiterate what Elise was just saying about needing your support. This will be a protracted legal battle, and it's your support that makes everything the center does possible. Paula and my contact information are now in front of you on the slide, and if you're in a position to make an impactful gift to this effort, please reach out after the call. This is a fast-moving campaign, and your support can make all the difference. Laura will soon be also posting links to where you can also go to an online donation form and the action alert that Elise mentioned to help continue building public opposition to this project. So from here, we're going to go ahead and open this up to a Q&A and get started on that part of the presentation. So we do already have just right out of gate, I think a great comment, because I know this was on your mind a lot, Elise and Jason. So from George, we have a comment. I've seen many TV stories on different local network and cable channels on Alligator Alcatraz, and never once did he hear it called Big Cypress National Reserve. And just suggesting, urging everyone to use the term Big Cypress National Preserve in every interview, because knowing that it's ecologically valuable, a national protected area, should help with public opinion. Many people need to know that this is a huge environmental issue. I don't know if you
Yes,
want to comment on that. Yeah.
I thank you, George. We think about that all the time, and you're exactly right. And it's not by mistake that people call it the airport site or they call it, the Alligator Alcatraz. It's to detract from the fact that this is in the middle of an ecologically sensitive area, and that neither the federal nor the state government did their due diligence to protect our waters, our clean air, and the public lands that we all love. And so it's something that we take to heart, to point out that this is the Everglades. This is a federal immigration detention center in the Everglades. I think it's also worth noting that, the name Alligator Alcatraz is cruel. And it's a reminder that an administration who's willing to treat people so horribly is going to treat the environment even worse. And that's why we're here. We care about biodiversity, we care about the environment, and we care about communities who depend on these places for our livelihood and our happiness and our health. So I just really appreciate that insight and that thought. And I think if we all picked up on that, we could maybe change the narrative.
Yeah, absolutely. So we have another person here, Natalie, who just wants a little more specificity of who are we suing, which agencies, and who is the responsible party in the suit.
I'll take that as an initial matter, and then perhaps Jason can speak a little more to the endangered species issue. But interestingly, and maybe surprisingly for many, that the state agency that we're suing is the Florida Department of Emergency Management. It's the department that responds to hurricanes. It's the one that sets up tents when you need shelter and provides food and sandbags. And that seems really odd, right? It seems odd that an agency that's dedicated to responding to emergencies would be facilitating detaining people in the Everglades. And that's actually another of the claims that we brought in this case, is exactly that this agency isn't even authorized to be doing what it's doing in the middle of the Everglades, aside from the fact that they've bypassed all of these environmental reviews. And perhaps Jason can speak a little bit more to the Fish and Wildlife Service's role in those Endangered Species Act claims.
Sure. So we're also bringing suit, as we already have, against defendants, the Department of Homeland Security and ICE. And with respect to the ESA for their failure to consult with the U.S. Fish and Wildlife Service. Additionally, claims to be brought against the National Park Service, the Secretary of the Interior, that's the Department of Interior, for just abdicating their responsibilities under the National Park Service Organic Act. There's a lot of defendants here, but I think it's reflective of just fundamental widespread failures at the part at the federal level, as well as the state level for causing harm to these species. So a number of different defendants, and but again, I think it reflects pretty widespread systematic failures throughout the duration of this project.
And we have another question here from someone just getting at the scope and scale of attacks like this on amazing places. And Robin says, I live near Yellowstone National Park and I've lived 55 years in Alaska with Denali and other parks. This threatens them all if the Trump administration gets off completely on this one. Is that right?
Yeah, I think
can
there's
take-
significant. Oh, go ahead, Jason, please.
No, go ahead, Elise.
We're both very deferential to one another. I'll go first, and then if you'd like to dive in, Jason. I was just going to say that I think that's absolutely a concern. And I think that we've seen administrations at the state and federal level emboldened by this win that they've gotten recently and making arguments that further weaken our environmental laws. And what we know is that the public supports these laws and we want them. So everything that's happening in court right now really goes against the wishes of the American public and against our health and welfare and happiness. Sorry about that, Jason.
Oh, it's okay. No, I absolutely agree. I think, like going back to Allsteiner's quote, it's America's best idea. And I think with national parks in particular, people, regardless of your background, socioeconomic background, your political persuasions, all tend to rally around national parks. It's something that I think binds us together. And to see right now an administration that has just simply remained silent and taken no action to protect this park from these places, I mean, from this project, is quite troubling. And I think it could have repercussions down the road, particularly if it signals what I think we perceive as a total lack of priorities here. What's interesting is that, on a pretty routinely weekly basis, the Interior Department, which is charged with overseeing the National Park Service and other agencies, puts out a weekly news blast. And there's so much of it is focused primarily on oil and gas development throughout the country. Very little is actually mentioned that talks about conservation, much less the protection of national parks. And so when we're staring down a project like this, which is continuing to have weekly, monthly, significant harms caused to these species, that the Park Service, Fish and Wildlife Service, all of these agencies under the umbrella of the Secretary of the Interior are charged with protecting. It doesn't bode well for the future right now. So that is another reason I think that action has to be taken to rigorously protect our national parks. And going back to the previous point, I certainly agree. I feel like what's been lost in this entire narrative publicly is this is a national park, for crying out loud. It's something that we should all stand up and take note of and defend.
Absolutely. We have a lot of questions here, and just comments about, there's someone here who is representing a conservation focused nonprofit in Northwest Florida, feels a little removed from the Everglades, but still it's part of their state. And, what can organizations or individuals do to support right now?
Sure, I can start with that one. And as somebody who lives in the Tampa Bay area, I know that feeling of feeling removed and wishing I was there, every minute to help out on the ground. I'd say, in addition to supporting the center and our partners as we move forward with this case, following the lead of Miss Betty Osceola, she's been leading rallies, peaceful protests at the site weekly. And there's also been every Sunday a vigil, a faith-based vigil where folks can come out to the site and show their support for the environment and for the people who are detained in that facility. The environmental threat does go hand in hand with a lot of other threats with this project. And, to the extent you can go down, or if you can't, you can tune in on social media to show support. That can go a really long way to just showing that this is unpopular with the public widely, across political stripes, across religious beliefs, across priorities. Not everybody wants to be waist deep in the middle of Big Cypress, but they still care about it. And so I think there's everything you've listed is helpful. Calling your legislators, sending those comments, but definitely following the lead of the tribe who have the most at stake here, living so close to the site.
Here, have some more specific questions. We have a question here about, were there any weaknesses in the laws themselves that allowed the government to win on their first appeal in NEPA or in the ESA?
Yeah, I mean, I would say it's not the laws themselves. What's really fascinating about these laws is that Congress intended us, the people, to enforce them when the government failed to comply or failed to uphold these laws. And so in that sense, the laws are working as they were intended, for private citizens to protect the environment when needed. But it certainly is troubling to see interpretations of laws like the National Environmental Policy Act that limit their reach, because this is truly one of the most common sense of all laws we have. Why would you not look before you leap, understand what the risks and pitfalls are? And so, I think it is concerning to see this turn of events, but that's also why we're here, making the arguments and explaining why these laws are powerful. And I should point out too that other conservation groups actually filed a friend of court brief in the case to point out this exact issue. There are state and federal partnerships in the Everglades all the time. And often it's to restore the Everglades, and those projects require environmental review. So the idea that a development in the same place would not require that review is outrageous. And we stand forward to fight it back and to point out how outrageous it is.
We have another kind of specific question here. Does the Endangered Species Act encompass noise and light pollution?
You want to take that one, Jason?
Sure. So it can encompass things like pollution, like light, noise pollution, whenever a species is harmed in such a way or harassed in such a way that it interferes, for instance, with like normal behavioral patterns such as feeding, foraging, hunting, its reproductive cycles. So anything that creates that level of disturbance um, through activities that might fall short of someone, for instance, directly killing or injuring a species, with a weapon or clearing its den site or nesting site. So the Endangered Species Act does regulate a variety of different activities that could cause harm or harass a species to the point where it's interfering with those behaviors and those are kind of essential parts of a species life cycle. So yes, light pollution in this instance with the panther or with the Florida bonneted bat, for instance, and how it interferes with their ability to forage at night with catching insects in the sky.
Great. We have an interesting question here from Paula. Have the agencies taken any actions to address the harms that have been incurred so far?
Unfortunately, not that we're aware of. I think largely the response that we've gotten, at least in the public forum, is there are no environmental impacts at all, which is absurd. We know that's not true. They've pointed to some silt fencing along the edges of the site that's often used to basically just keep silt or sand from washing off into wetlands. But that doesn't stop pollutants from going through. It's a mesh with holes in it. We've pointed out the lack of waste, stormwater structures to protect the surrounding wetlands. We've pointed out the harms to panthers and Florida bonneted bats. If they wanted to, they could shut off those lights, but they don't. And I think that's for a reason, right? Right now what we're seeing is a push to get away with as much as they can on this site. And that's exactly why we think it's so important to stand strong, to be prepared, to have our experts lined up. And so when we're finally ready to move forward, we can push as hard as possible.
We probably have time for about one more question. This has been great. So many questions. The last one is one I think that's very commonly on people's minds is just to get a little insight into what it's like to be you and how do you work with the other groups that you work with and the tribes, and how do you divide up responsibilities? Take us in to how you approach it as a team.
Jason, maybe you'd like to kick this one off. Jason has a long history in the Everglades Coalition, where we work closely with partners all the time, and I'd love to tag on to the end.
Yeah, we've worked so closely with so many different stakeholders and environmental organizations, conservation groups, indigenous peoples. I think we all just share a real passion and love for these special places. And when I reflect back on my time, both at the center and prior to joining the center, which much of my work was focused on advancing Everglades restoration, you know, everybody agreed. And that includes government, and NGOs and the public. That in order for us to restore the Everglades, we all have to be in on this, and we all have to be together. And at times, you might find differences, but it's not those. It's oftentimes just differences in perhaps strategies or tactics or that sort of thing, and not differences in our fundamental goal, which is to see in Everglades, reborn and perhaps flow once again. I mean, we may never get to where it originally was, hundreds and hundreds of years ago. But we've certainly have continued to make a lot of progress, and there's a lot of promise ahead for a restored Everglades, despite what we've done, to the system over time, as development has encroached and all. But I think that's frankly the part I enjoy and love the most. Oddly enough, working with so many people, because everybody kind of brings in a different perspective, a different interest, a different love, a different passion, but we're all kind of centered and focused in on this ultimate goal. And I think it's reflective with things, such as the Everglades Coalition now with over 60 something members, organizations and groups. So I hope that answers your question. We try to be as inclusive and as possible here at the center, and we feel that there's strength in numbers and strength in diversity and strength in coalition of voices. So that's what keeps me going and what I really love about my work.
Jason, you said it so well. I think the shared love for this place and for this work and for the creatures who live in the Everglades really, they help us to get past any differences we might have, to come together to do something that's really important. And I think that, not to sound kind of kitschy, but many hands make light work. And in fact, I think there's joy in the work when you're working with people and you're trying to protect something so precious and so important. And it's that love and that joy and that partnership in doing something together that really keeps us going, even though we're facing a really dark and awful and scary project. And so I think one thing that I know for sure is that we are, just constantly sort of energized by each other and by that working together. And to date, I think it's worked really well in this case. Sure, we've hit a minor setback, but we feel really confident about this appeal and that we can come out and vindicate that injunction and then move forward with the actual case and finally show once and for all of the harm that should have been reviewed and should have been made publicly available so that all of us could understand the consequences.
Well, thank you again, Elise and Jason, for everything that you're doing for the natural world in dire times. And a huge thank you to everyone who took the time to join the call today. Final reminder, we will send you a recording of the briefing soon, and we'll have a transcript available upon request. But please don't hesitate to reach out to us after the call. We would love to connect with you. And thank you again, and have a great afternoon.